On May 8, 2023, Corey Richens was arrested and charged by Summit County, Utah, on multiple counts, including aggravated murder and insurance fraud, for allegedly poisoning her husband, Eric Richens, who died from a lethal fentanyl overdose on March 4, 2022. Investigators revealed that the couple was experiencing severe marital money problems and financial disputes throughout their marriage, which prosecutors pointed to as a primary motive behind the crime. An amended charge of attempted aggravated murder was later added to address an earlier alleged poisoning attempt on Valentine's Day, February 14, 2022. Parallel to the wrongful death action, a major civil lawsuit erupted over Eric's estate. Ms. Richens sued Katie Richens Benson, the trustee of the Eric Richens Living Trust, claiming ownership of $2 million in business buyout proceeds. The legal battle centered on whether Mr. Richens' pre-death transfer of his C&E company interest into the trust was valid. On August 3, 2023, a hearing on competing motions for partial summary judgment was held in Utah's 3rd Judicial District Court before Judge Richard Mrazek. The arguments were presented by attorney James Tracy, representing defendant Katie Richens Benson, attorney Deborah Chandler, representing intervener Eric Richens' minor children, and attorney Austin Nate, representing plaintiff Corey Richens, who opened his oral argument by referencing the plaintiff's motion for partial summary judgment.
First, in your view, how does the fact that a transferred or revocable trust doesn't put assets beyond the reach of creditors affect the application? How does it, the argument, right, is it's as if the assets weren't transferred from a creditor's perspective. They're still reachable under Utah code.
So I think there's two ways to address that, Your Honor. And the first is, and of course, as you mentioned, there's bleed over into the other motions that are issued. And I think this particular issue, lends itself to that specifically. Because one of the positions that the defendant has taken in this case is that Eric no longer had anything to convey to him or convey to Corey upon his death. And essentially it was out of her reach at that point because it had been transferred to the trust.
Right, but I'm asking you a different question. So put that as your side. Let's assume that the money, the buy-sell proceeds, if I recall correctly, nobody in the case is asserting, or Corey, forgive me, is not asserting unwind the assignment, I want the membership interest. Rather, she's asserting an interest in the full amount of the buy-sell proceeds. Is that correct?
That's correct.
Okay. And so let's assume for the purposes of our discussion, just for now, that that's a $2 million sitting in court that she asserts a claim to, and that she is a quote-unquote creditor. Why is her ability, interest, efforts to secure her interest in that $2 million hindered, delayed, defrauded in any way by their fact that they're currently being held, at least nominally, by the revocable trust? Can she reach them?
Right. Yes, Your Honor. I think she absolutely can reach them. And, that's why we cited that in our reply in the voidable transfers motion, is because we think that position is diametrically opposed to the other positions that's been taken with respect to the motion for summary judgment, the cross motions for summary judgment. We think there's some conflict there. And so in the event, as we believe, that under the Utah code, she can directly access that under the arguments that have already been made, then the voidable transfer, I don't want to say it's not necessary, but I think there's a much clearer way to resolve the issues that are outstanding here instead of setting the transfer aside, if that makes sense.
I agree with the last part. I think with respect to everybody that's filed a motion here is that's for more relief than they're entitled to, if they're entitled to any. Your motion, though, seeks a ruling as a matter of law that this was, in fact, a voidable transfer and that it should be unwound, meaning nominal title to that $2 million should be held in the name of the estate of Eric Richens, not the revocable trust established by Eric Richens. Am I right about that?
That's correct, Your Honor.
Okay. But it's the same from a creditor's perspective, right? Whether you execute a judgment against the revocable trust or you execute it against the estate, there's no difference, is there?
Honestly, Your Honor, I think there may be some difference to a degree, but again, at the end of the day, based off of the defendant's position in the opposition, in which again we reiterate in the reply that it's accessible just simply under the statutes of the trust code, then I think we would agree with you that unwinding the transfer may not be necessary, or we may not even need to get there, simply because if Corey is in fact a creditor, and I think that's the critical question here, and is admitted in the opposition, that if Corey's a creditor and therefore, has a claim for purposes of the statute, then really there's no need to go through this process of dealing with avoidable transfer because there's a much more direct way of going about it.
I agree there's a more direct way. I think you may be reading too much into their concession. I read their brief as saying, we concede that she falls within the statutory definition of a creditor, not that Eric Richens had a business interest to transfer at the time of his death. He'd already transferred it in a way that doesn't breach the prenup.
Right. And I don't want to correct, I don't want to, say what their position is or anything. I'm sure, they'll get up here. I do think they do dispute that Corey's a creditor, though, in the briefing. I think they dispute that there's a creditor-debtor relationship that existed here under the underlying documents and the claims that have been asserted. It's very clear a creditor is an individual that has a claim, and a claim is defined very broadly under the Act. So we think, as a matter of law, Corey is absolutely a creditor under the Voidable Transactions Act. And
but given the breadth of the definition of creditor, isn't it true as a matter of law that you can be a creditor by virtue of an allegation rather than an adjudicated fact, right? That's
correct. Right, exactly right. The statutory language says it can be a disputed, unliquidated, contingent, right to payment. And so, clearly we say that Corey is a creditor under these circumstances.
Judge Mrazek stated that he cannot grant summary judgment at this stage, reinforcing that unresolved factual disputes remain regarding whether Ms. Richens legally qualifies as a statutory creditor and whether reasonably equivalent value was exchanged when Mr. Richens transferred the assets into his revocable trust. Under Utah Rule of Civil Procedure 56, a court cannot grant summary judgment while there is any genuine dispute of material fact that must be tested and proven in further court proceedings rather than decided purely as a matter of law. During oral arguments, Mr. Nate leaned on the position that Ms. Richens qualified as a statutory creditor entitled to seek relief under the Utah Uniform Voidable Transactions Act. Under Utah Code 256102, a creditor is defined broadly as anyone who holds a claim, which includes any right to payment regardless of whether that right is disputed, unliquidated, fixed, or contingent. Here, the dispute centers on whether Ms. Richens' asserted rights under the underlying prenuptial and contract documents actually establish a valid debtor-creditor relationship, a status that Mr. Tracy's side actively contests.
But with respect to, my recollection is that the position that a transfer to a revocable trust can't constitute a voidable transfer for purpose of the Act. My recollection is all the case law is foreign case law, nothing that would be specifically binding on this court. And at the end of the day, we cited case law, which I will mention as well, is from an outside jurisdiction, but we think it's illustrative that these types of revocable trusts can be used as an instrument to do exactly what what the Voidable Transaction Act seeks to avoid, which is to put things outside of the reach of creditors under that very broad definition. And specifically the Pandy case from Colorado that we cited, again, recognizing that it is not binding on this court, but it specifically addresses the idea that a debtor should not be able to have all the benefits associated with a revocable trust to the detriment but be able to shield that from all the creditors.
But if I read the Utah Probate Code correctly, there is no limitation on the post-death susceptibility of an asset that was contributed to a revocable trust during the testator's life to claims of creditors. It's as if it was just sitting in the estate of the individual, right?
I think you're correct, Your Honor.
Okay.
Yes.
And so I think their argument was categorically, as a matter of law, transfers to a revocable trust cannot be within the purview of the Act. Now, in fairness to you, you say, all right, they're not in the purview of this section of the Act, but what about the no equivalent value? Would you acknowledge there's at least an issue of fact as to whether or not $2 million is equivalent value? I don't know that I can grant summary judgment on that.
Could you clarify your question? An issue of fact on the value on that value, or
two different sections of the Act?
Right, correct.
Or two different, I guess we'll say, silos of the Act. One is creditor, debtor, transfer with the intent to hinder, delay, defraud. That'll be category number one. But then there's a second category of creditor, debtor, transfer, not for equivalent value, substantial value.
I think it's reasonably equivalent value.
That would not be affected by the assignment, right? Or I guess that would not be affected by this argument related to categorically putting it in a revocable trust. That's a separate issue, right?
Right. Yeah, I think so. Yes.
But here you are asking for summary judgment, meaning undisputed facts, ruling as a matter of law. This was in fact a voidable transfer. In order for me to rule in your favor on that second category of argument of the act, I would have to rule as a matter of law that $2 million wasn't enough. Right?
So the $2 million was not. So 202 is actual intent to hinder, delay, or defraud, and 203, subsection 1, is that a transfer is voidable if the debtor made the transfer without receiving a reasonably equivalent value in exchange for the transfer, and 2, the debtor was insolvent at the time or became insolvent as a result of the transfer.
And what I see them saying is myriad issues of fact. You haven't proven it based on undisputed facts as a matter of law. What's your response to that?
Our response is they haven't provided any evidence any admissible evidence to the contrary. Right?
You have the initial burden here of production and persuasion, and they're saying you haven't met it. Tell me why you had it.
I think we met it, Your Honor, because first we have the testimony of our client as to the assets that were owned that she was aware of at the time of the transfer. In addition, we have the additional debts that we know existed. I don't think there's any dispute as to at least the first mortgage debt. Certainly there's a dispute as to the second one right now. But even if you disregard the second mortgage, with respect to the first mortgage, they haven't identified, or we have come forth with evidence, testimony from our client, stating that Eric's assets did not exceed $200,000, but that his debts did exceed $200,000, and we have that demonstrated by solely the amount of the first mortgage on the house, right? So with that testimony and providing, the fact that debt existed at that time, we think we've met our initial burden to demonstrate that those were the amounts of Eric's assets, those are the amounts of his debts, under the terms of the act that constitutes insolvency, and therefore...
Those numbers by me one more time. I didn't hear you say the words $2 million.
Correct. I did not say the words $2 million. And I think here, because the focus is on the debtor receiving a reasonably equivalent value, so that would be Eric receiving value, not the trust, right?
Your entire argument, though, that he as trustee and he as individual are one and the same for the purposes of this analysis, and so if he as trustee is going to receive $2 million from the buy-sell, he as individual receives it as well?
To a degree, yes, Your Honor. I don't know that we would say that it's, yes, we think functionally it is one and the same, but again, we are taking the arguments that we've received from the other side that there is this distinction here, right? And so, had the position been taken that, or without the initial position that the fact that Eric did not have, possess, or own this upon his death, if that position was not taken, it's highly unlikely we would have brought this motion in the first place.
Judge Murzik asks Mr. Nate what proof they actually have to meet their initial burden of production to grant a summary judgment under Rule 56, challenging whether they provided admissible evidence to prove insolvency as a matter of law. Mr. Nate relates to the first mortgage debt that Mr. Richens had, explaining that based on Ms. Richens' testimony, Mr. Richens' personal assets did not exceed $200,000, while his liabilities did exceed $200,000, thereby demonstrating that Mr. Richens was insolvent at the time of the transfer. Under Utah Code Section 25-6-202, a person who transfers property with actual intent to hinder, delay, or defraud a creditor commits a voidable transfer. In this case, Mr. Nate relied on this actual intent provision to argue that moving assets into the trust was an illegal attempt to shield property from creditors. Under Utah Code Section 25-6-203, the court must determine whether a debtor received reasonably equivalent value. Judge Mrezek brings up this requirement when asking about the $2 million received in connection with the buyer-sell agreement. He points out that this issue involves a genuine dispute of material fact rather than a pure question of law. The judge explains what would be required to grant summary judgment in Ms. Richens' favor under Section 203. He would have to rule as a matter of law that $2 million was not reasonably equivalent value. However, he cannot make such a ruling when the underlying facts are actively disputed. Therefore, the $2 million received by the trust creates a major factual dispute. Ultimately, this unresolved issue prevents the court from granting summary judgment under Rule 56. After Mr. Nate finishes his arguments, Mr. Tracy starts his arguments.
Well, Your Honor, we agree that the problem with the voidable transfer It doesn't fit the facts of this case. It doesn't fit. A voidable transfer is a remedy for creditors to get at assets that debtors have tried to put outside their reach. As you mentioned, and we've cited in 75-7505, it's very clear under the trust code that assets held in a revocable trust are subject to the claims of the creditor during the grantor's lifetime.
What about the Section 203?
Well, so 203, now that, and I do think it's important to look at the difference between Section 202 and 203. To remind ourselves, on Section 202, that's where you have a claim that arose either before or after the transfer. I don't see how Corey could have possibly had a claim before the transfer, but we could talk about that.
Prenup was in existence before the transfer.
Right, but what claim did she have?
Well, it would be a contingent claim that by this transfer you are undermining that which you agreed to in the prenup. Now, we have a whole colloquy, I just got into it, I've done it anyways, but
exactly.
The Act provides a different overlay.
It does, but I think it's an important point to talk about whether she was a creditor, whether she had a claim, and if so, was her claim before or after the transfer? I think that, and we do take the position that she wasn't a creditor, that she didn't have a claim. But let's take your hypothetical. Before the transfer to his trust, let's say he sells it for $500,000 to a third party. Does Corey have a claim?
Maybe the $500K. I think that's what Mr. David says. That's traceable at this point.
The question is, though, did he breach the prenup? And I think, as Your Honor noted, he could have done anything with it. So our position is there was no breach of the prenup because Eric wasn't obligated to keep it in place for her. If Corey was worried that he might do something like sell it, she could have negotiated that as a part of the prenup. She didn't.
But in fairness, and without naming names, I'll give you an example that's come up in a divorce case in Summit County. Husband transfers an asset to a third party, gets a divorce, reacquires the asset. It looks like a sham. The Act applies to that situation.
Absolutely.
And so if that's the case, why wouldn't, I mean, we can't say that the Act doesn't apply categorically if, for example, spinning a hypothetical here, Eric transfers his business interest in C&E to a third party for $100 or $1. After his death, his estate, the trust, maybe his kids reacquire it for $1. It starts to look a little more shady. And so that didn't happen here, I acknowledge. But in terms of trying to determine whether or not the Act can apply to the facts of this case, why don't we have to contend with Section 203?
Well, let's look at 203. We don't think she's a creditor under 202 or 203. And the reason is because the prenup did not restrict Eric in any way from disposing of his asset, and that governs. If he had disposed of it, she wouldn't have a claim. So we don't think she's a creditor. That's our position. But let's look at 203. 203 applies for claims that arise before the transfer, not after, and if the transfer was done without reasonably equivalent value and you're insolvent. Well, first of all, when you make a transfer to your revocable trust, well, and particularly in this case, the trust says all of those assets, every penny, are available for Eric's use. They cannot show it wasn't for reasonably equivalent value, because if he had, by the way, what did he have? He had a business that's worth at least $2 million. He has a house that's worth $1.7 million. The first mortgage was $260,000. The second mortgage, which we think was fraudulently obtained with fraudulent powers of attorney, was $250,000. But even if you take those together, that's $500,000 on a $1.7 million house. Plus, Katie filed a declaration that says he's got other funds, stocks, vehicles. I don't think this is a close call on solvency, but they clearly can't meet the burden of proof on insolvency. But in any event, Your Honor, there's clearly, if you take what we just talked about, $2 million for the business, $1.7 million for the house, minus maybe $250,000 for a mortgage, you're well over $3.5, potentially $4 million. Every penny of that in the trust is available for Eric. How can that not be reasonably equivalent value? It went from one place where he could use it to a trust where he can still use it.
So in terms of the ruling you'd request on plaintiff's motion for summary judgment on their seventh claim for relief, you didn't file a cross motion on that claim.
We didn't.
Is it just deny the motion, or is it rule as a matter of law that transferred or revocable trust is outside the purview of a 202 claim and deny the motion, the remainder of the motion?
Yes, the latter, Your Honor. You know, as it goes in summary judgment motions, you may not file a motion, but if the ruling comes down, it's law of the case, it effectively disposes of the claim.
Well, disposes of that part of the claim.
Yes, yeah. So we don't think she's a creditor before or after the transfer. We certainly don't think there's any actual intent to delay, hinder, or defraud because the assets are there available to creditors during Eric's lifetime. They can't show that it was without reasonably equivalent value because all of the assets that were there before were still available for Eric's benefit, and they can't show that he was insolvent. In fact, it looks like he wasn't insolvent. He was solvent by somewhere approaching $4 million on the plus side. So for all of these reasons, we think that the summary judgment motion on voidable transfer should be denied.
Okay.
Mr. Tracy affirmed that Mr. Richens had almost $4 million in assets to his name, proving he was overwhelmingly solvent at the time of the transfer under Utah Code Section 25-6-103. Under Utah Code Section 25-6-203, Mr. Tracy argued the transfer was not made without reasonably equivalent value because moving the business into a revocable trust retained 100% of its economic benefit from Mr. Richens. However, Judge Mreza questioned whether 25-6-203 must still be evaluated, posing a hypothetical $1 sham transaction to illustrate why courts must formally scrutinize whether such transfers meet the statute's requirements. Under Utah Trust Code, Section 75-7-505-1, Mr. Tracy explained that assets transferred into a revocable living trust remain fully subject to creditor claims during the grantor's lifetime. Beyond establishing that Ms. Richens was not a creditor under Sections 202 or 203 of the Uniform Voidable Transfers Act, Mr. Tracy argued there was no breach of the prenuptial agreement because Mr. Richens was under no contractual obligation to preserve or keep the business interest in place for her under Utah Code Section 30-8-4. Specifically, Mr. Tracy reasoned that Ms. Richens could not be considered a creditor under Utah Code Section 25-6-1024 because she held no enforceable legal claim under Utah Code 25-6-1023 against Mr. Richens before or after the transfer. Because the prenup designated the business as Mr. Richens' sole separate property with absolute freedom of disposal, moving the asset created no breach of duty, no legal injury, and no debt, leaving her without any underlying claim required to trigger the Voidable Transfers Act. After Mr. Tracy finished his arguments, Ms. Chandler had the opportunity to start hers.
I was not a party to this when these briefs started, so I will keep it short. There is an extra avenue I think we need to look at, though, the facts of which have arisen since the original briefing, and it's this. Eric died on March 4th, 2022. And under Utah Probate Section 75-3-803, Corey had a year from the date of his death or 60 days from receiving written notice or notice of publication to present a claim to the estate. While she did initially timely file a notice of claim in the estate case, that claim was solely based on the allegations made in the trust complaint. There are no personal allegations against Eric. These claims were then disallowed by the PR on April 12, 2023. Utah Code Section 75-3-804 subsection 2 requires that a proceeding be commenced within 60 days after the personal representative has mailed the disallowance of claim. To date, there is no proceeding that's been initiated and the time to do so has passed. So,
wait a minute. This has not been briefed.
It has not, Your Honor.
I'm sure I understand to see where things are headed. So,
if Corey doesn't
the
have
moment Eric dies, right, the business interests, the buy-sell proceeds, which have not been liquidated yet but are coming, are either in his personal estate or in the trust.
Yes.
Your side of the room says in the trust.
They are in the trust.
The trust gets administered according to its terms. Corey doesn't have to make any claims, right?
She does have to make a claim if she's going to contend a fraudulent transfer, because Eric has to be the debtor. So on all sections of...
But if it's in his estate, this is where you're telling me Deadlines with harsh results kick in.
That's correct. If she didn't make a claim but in the estate and pursue it within 60 days of receiving that notice of disallowance, those claims are now barred.
And when you say claim, is that her argument under the Act?
It would be a claim that she has any claim against Eric, right? Whether it's breach of the prenuptial agreement, breach of the duty of good faith and fair dealing. So without those, a claim on that she owns half the house. Without those, there can be no debtor-creditor relationship, Your Honor. And every section of the Utah Voidable Transaction Act requires a debtor-creditor relationship as a predicate to asserting the claim.
With the, I'm going to put you on the spot here, and I'll understand if you're not prepared
Yeah.
to answer. This is new. I'm not going to make any rulings on this today, Mr. But if the house is in the trust, we just apply the trust, right? Subject to acknowledge there's a Slayer statute issue sitting out there.
She can make a claim as to whether she's a tenant in common with the trust.
Right.
But to the extent she has some claim against Eric as a debtor, she's lost that.
Okay. You're going to have to brief that. You
Okay.
can't rule today.
That's fair.
Talk to me about the arguments that were briefed. Anything to add on this?
I think that the argument, there's a valid transfer here. To the extent that that transfer did something that the prenup, I think on the face, the prenup allows for that. To the extent that that violated, I think the only issue would be a duty of good faith and fair dealing. As to Eric or some other frustrates the purpose of the contract, those claims were against Eric personally, and they need to be brought against him personally. I don't know if you can, I don't think that claim goes against the trust, because the trust would be the same as a third-party transferee for the purposes of this. She didn't have a vested interest, and Eric could do what he wanted with this. And so when he transferred it to the trust, it was a valid transfer. It sits in the trust unless she can avoid it somehow. She can't avoid it through the Fraudulent Transfer Act because she's not a debtor.
Because the condition precedent hasn't kicked in yet?
Because, yes,
But the definition of claim talks about contingent claim.
can't be contingent. At best, she had a contingent, unliquidated claim that can now never be liquidated because it's time barred.
Initially, Judge Mrazek observed that if the assets were in the trust would simply be administered according to its terms without requiring Ms. Richens to file an estate claim. However, Ms. Chandler clarified that to challenge transfers or establish Mr. Richens as a debtor, Ms. Richens was required under Utah Probate Code Section 75-3-803 to file personal claims against his estate within the statutory timeline following his death on March 4, 2022. Ms. Chandler pointed out that because Ms. Richens only filed a notice based on allegations in her separate trust complaint, she failed to assert any direct personal liability or debt against Eric himself. Furthermore, under Utah Code Section 75-3-804(2), once the personal representative formally disallowed those claims, a court proceeding had to be commenced within 60 days. Because the required 60-day window passed without court action, Judge Mrazek acknowledged that deadlines with harsh results kicked in, rendering her personal claims against the estate permanently barred. Without those active claims, Ms. Chandler argued that Ms. Richens could not establish a valid debtor-creditor relationship with Mr. Richens, because every section of the Utah Voidable Transactions Act requires a debtor-creditor relationship as a necessary predicate to challenge asset transfers. She lacks standing to assert those claims. At the end of the hearing, Judge Mrazek ruled denying Ms. Richens' motion for partial summary judgment and granting partial summary judgment to the trustee, Katie Richens Benson. The court held that Mr. Richens' 2021 transfer of his C&E business interest into his revocable living trust was lawful and valid under Utah law. As a result, Judge Mrazek determined that the $2 million buyout proceeds belonged to the Eric Richens Living Trust rather than Ms. Richens, preserving those funds under the control of the trust for the benefit of the children. The civil litigation was ultimately settled not in civil court, but by the outcome of the criminal trial. On March 16, 2026, Corey Richens was convicted of aggravated murder, attempted aggravated murder, insurance fraud, and forgery, for which she was sentenced on May 13, 2026, to life without parole. Under Utah law, this felony conviction automatically stripped Ms. Richens of any legal right to Mr. Richens' estate, trust proceeds, or property, securing the $2 million business buyout and remaining assets entirely for the children. This case illustrates the critical importance of statutory interpretation and evidentiary protocols in civil proceedings, especially when parallel criminal trials are underway. way. While Mr. Nate's arguments relied heavily on the Utah Voidable Transactions Act, claiming that Mr. Richens' 2021 assignment of his C&E business share was an unlawful transfer designed to hinder Corey's marital rights, Mr. Tracy countered with evidence of Mr. Richens' substantial solvency and separate property rights under the couple's prenuptial agreement. Mr. Tracy demonstrated that transferring an asset into a revocable living trust did not shield it from legitimate creditors, nor deprive Eric of its economic benefit during his lifetime. By carefully weighing these conflicting legal theories and statutory frameworks, Judge Mrazek ruled in favor of Mr. Richens' trust found, denying Ms. Richens' motion and granting partial summary judgment to the trustee, confirming that the $2 million buyout proceeds rightfully belong to the Mr. Richens Living Trust. Comment below if there is a case you would like to see. Subscribe for more case analysis.